Hi everyone, and welcome to Legal Aid Queensland's webinar, Living with Domestic and Family Violence, Part 2. My name is Catherine Bowden and I'm the Communication and Community Legal Education Officer here at Legal Aid Queensland. And sitting next to me is our lawyer in the Violence Prevention and Women's Advocacy team, Jason Derrick, who I'll introduce you to again soon. All right, now I'd just like to begin today by acknowledging the traditional owners of the land on which we meet today and pay our respects to elders past, present and emerging. Now today's webinar is for community legal education purposes only. All right, just a quick housekeeping slide before we begin. If you are having any technical troubles, the number to call is 1800 136 402. If we have a technical fail on our end, I will try and fix that as quick as possible, but if you can't hear us, you're still welcome to post comments and let us know. All right, now the webinar will be recorded today and you'll be able to access that later by going through our information for community workers and carers page on Legal Aid Queensland's website. You'll find a YouTube link and that'll have our past webinars as well. So if you're interested in Jason's part 1 after this, if you haven't watched it yet, then you're welcome to go on and watch it. We've got other legal topics on there as well. Okay, if I could ask you all to download the handout now, that would be great. You'll be able to see the handouts toolbar on the side there. And you can also see the questions box when you're ready to ask questions as well. Okay, we're going to start with a quick poll before the presentation. So this just helps us frame our webinar. We're interested to know what region you work in, whether you're in Southeast Queensland, which it looks like a lot of you are so far, Far North Queensland, regional or outside of Queensland. I can see there's a few of you from outside of Queensland, so Jason will be able to let you know if this will be relevant to you as well. Okay, just close that now. I'll share those results with you if you're interested. So 70% are from Southeast Queensland and we've still got quite a few from Far North and regional Queensland and outside of Queensland. So welcome. Okay, and if you could also let us know how much knowledge you think you have on Legal Aid Queensland. That will just help us guide the level of presentation as well. So most of you have limited to good knowledge. You'll learn a lot more about us today too, I'm sure. Okay, just close that off now. All right, I'd like to hand over to Jason to speak to you about living with domestic and family violence, part 2.
Thank you. I would also like to first acknowledge the Aboriginal and Torres Strait Islander elders, which are the traditional custodians of this land. I'm from regional Queensland myself, so I grew up on Darumbal land, and I'd like to acknowledge the elders past, past, present and emerging as well. So today we're here to talk about domestic violence and about family violence and about the legislative response and the practical outcomes that can occur through the Magistrates Court of Queensland underneath the Domestic and Family Violence Protection Act. So today we're going to cover 5 points. And the reason why we're going to cover those 5 points is that today I want people to walk away with a practical understanding about what the legislation is aiming to do, what the legislation sets out are the requirements to obtain a protection order, identify what kind of orders can be made to promote the safety and well-being of people who live with violence and fear violence as part of their everyday lives. New aspects of the current law. So when we did part 1, it was very new, all of the changes. So when we say new aspects of the current law, it's a bit of a reminder of what is there what is there now, and how that's actually working as well. I won't go into too much about the theory behind it like I did in webinar 1, but I'll actually just be talking about what does that mean for practical outcomes for our clients. And I'd also like to talk about resources and stakeholders that can help you navigate a client through a legal system and through our legal system here in Queensland. I did note that there were a number of people who identified as being from out of Queensland. Our legislation in Queensland is only confined to the Magistrates Court of Queensland. There is some flow-over effects onto the Family Law Act and the Federal Circuit Court and the Family Court of Australia, but ultimately this is a Queensland-centric seminar. If you'd like to continue listening, by all means, it's always good to know about what's going on in other jurisdictions. I'm doing some research at the moment on the response to LGBTI violence in Canada at the moment, and comparing notes. So I do understand how important it is sometimes to see what people are doing in other jurisdictions. So if you are from out of Queensland, feel free to listen on, and certainly welcome. Next one, there we go. Okay, so keeping it simple. The purpose of the Domestic and Family Violence Protection Act is that the Act is to provide a protection for a person against violence committed or threatened by someone else if a relevant relationship exists between the persons. So that's a really legal way of saying if you were in an intimate personal relationship or a family relationship or a care relationship with another person, that there is a set of societal standards which the court will uphold about being of good behaviour to each other and treating each other with respect and care. Now, the legislation in its opening accepts a number of propositions as the foundations of this legislation. It acknowledges the international human rights treaties. It acknowledges that we have, as individuals, we have a freedom to live our lives free from family violence and free from violence in general. There is an acknowledgement that power imbalance is a cause of domestic and family violence. It acknowledges the statistical evidence which supports that men are the primary perpetrators of domestic violence against women. It acknowledges that there is a serious and long-term effect on people who live with violence, particularly on women and children. And it also importantly acknowledges that domestic violence can and will be considered as a criminal offence. So this part, we go into a bit of the legislation now and how it's applied. I do acknowledge that there's probably quite a few lawyers, social workers and people who work in the domestic and family violence space. Some of you may be working with homeless people, and some of you might not ever see or darken the doors of a courtroom who deals with this area of law. Sections 3 and 4 of the Act, which I'm about to talk about, the two sections which I primarily rely on in making submissions about what orders need to be made and why an order should be made on a temporary and a final basis. So the objects of the Act is to maximise the safety, protection and well-being of people who are living with violence, to prevent and reduce domestic violence, to prevent and reduce exposure of children to domestic violence, and promote accountability of perpetrators. The use of the words perpetrators sometimes is a sticking point. However, I do want to highlight that that's the language that has been chosen by the legislative drafters. People who use violence, there is a lot of research about the reasons why they use violence as a way of communication with their spouses and the world around them. Ultimately, what this Act is acknowledging is that part of the picture of addressing family violence is by helping educate and making people aware of how violence impacts the people and the world around them. The principles of the Act, again, critical in every submission that I make to the court. The principles of the Domestic and Family Violence Act is that the safety, protection and well-being of people affected by domestic violence is paramount. People who live with violence should be treated with respect. People who use violence should be held accountable. And we also recognise that there are certain areas of our community who are particularly vulnerable to violence. They are women, they are children, they are our Aboriginal and Torres Strait Islander people, they are people who live with disability. We look at people who have a background which is culturally diverse, the elderly, and also the LGBTIQ community. During this presentation, if I do refer to the LGBTIQ community, I may also use GSD, which is gender and sexually diverse community. The LGBTIQ community can sometimes, it's a very broad definition, and sometimes LGBTIQ is somewhat limiting and doesn't acknowledge the diversity within that community. So I may interchange between GSD and LGBTI if I refer to cases during this presentation. So just so that everyone's aware as I may move between the acronyms. It's also a principle of this Act to identify a person who is most in need of protection. Very important for people who are helping people through situations where there are cross applications before a court or threats of cross applications. The court must identify the person most in need of protection, okay? Importantly, pursuant to sections 3 and 4 of the Act, the whole point is that there is a response to family violence that must be civil as well as criminal. So it's a multi-pronged approach. So we've got another poll coming up. So we're just going to open that. I'd like to know a little bit about you. So if you work in a women's refuge, a domestic violence support service, a community support service, a men's support service or other, if you are a lawyer, can you tick other for me, please? Because that will just give me a bit more of an indication.
So we've got a lot of people coming through in other
and
community support
service. Excellent. That's a lot different to what we had 6 months ago, I think, 8 months ago when we did the first one. So that's good. All right, and then I think we've got, do we have another poll after this one?
We do.
Yeah, so who are your clients? So can you please tell me a little bit about who your clients are? You can choose one or more in this poll. So people who are from a culturally and ethnically diverse background, LGBTIQ community, the elderly, women or men. Right. That's a really great, we're looking at about almost everyone are working with women, a significant number are also working with men, 30% are working with the LGBTIQ community, and 40% are working regularly with the elderly community. And of course, what the statistics also strongly tell us is that people who work in this space are assisting clients who are from a culturally or ethnically diverse background. So your statistics back up why we're all here.
Yeah, exactly.
Okay, so now that you know a bit about the principles of the Act and how the Act communicates its message, it's now about getting into the nitty-gritty. How do you get an order? So when you're dealing with clients, we must consider Section 37 of the Act, which outlines the exact reasons or the exact criteria on which the court applies to make a protection order. You must be in a relevant relationship. There must be an act or acts of domestic violence, and an order must be necessary and desirable, I should say, and or desirable in the circumstances. Relevant relationship is defined as an intimate personal relationship or relationships, family relationship, or an informal care relationship, okay? So there are some important criteria around dependent relationships for daily living with informal care relationships. So what is domestic violence? Section 8 of the Act makes it very clear and sets out the number of different acts which are considered domestic violence. So physical or sexual abusive acts, emotionally or psychologically abusive acts, economically abusive acts. Economics is something that a lot of people who work in this space, economic abuse can be very broad. It can be someone who refuses to allow access to an ATM card, people who get doled out allowances is a common thread with people who are being economically abused. Non-disclosure, so they seek a party who might be using economic control or abusive acts, seek information about everything, every financial aspect of the spouse's life, but provides no information back. And that creates the power dynamic that informs violence. Threatening acts and behaviours, so you don't, threatening acts and behaviours also fit in with emotionally and psychologically abusive acts. Threatening behaviours, standing over people, and anyone who works in this space knows that you don't have to touch someone to intimidate them, harass them, make them feel threatened. I'm 6'4", so I acknowledge that as a person I'm incredibly imposing, if you don't know me, of course, but that can be a real power play that can be used, just the physical presentation to threaten. Coercive acts, which are acts which I can best describe as, if you don't do X, I will do Y. So it's putting a person into a position where their behaviour or their acts are a direct response to pressure applied by the other party. And any behaviour that in any way controls or dominates or causes fear to a person, again, when you're dealing with power and control in relationships, it can metastasize in different ways. It can influence so many different behaviours of a person. They can decide not to go to work. They can decide to be scared of going to work. They're always conscious about leaving work on time because they can't possibly be late going home. There are a lot of factors which go into control and domination, and ultimately it's motivated by fear. What is the consequence if I don't pursue this course of action? So there are some other really clear examples provided in the legislation. Unlawful stalking, unauthorised surveillance. Anyone with a Samsung phone should probably always get that phone checked over, because you can remove the backs of those phones and a handy little device can be inserted into them. Apple iPhones are a little bit different, but anything that you can remove the back of a phone and insert a tracking device is a pretty common occurrence. Threatening self-harm or suicide, harming or threatening an animal. That is another one that's very common. People just stop feeding the family pet when a party leaves, and that's part of the motivation of the person to return to a relationship. Threatening harm or injury to another person, so that can be their friends, their family, work colleagues even. So it can be something that's quite serious and harrowing for a person who's living with violence. Oops, I've just buggered that. Oh, sorry, there we go. I clicked on the wrong part of the screen, everyone. I apologise. So something that I also want to really talk about is children's exposure to domestic violence. Now, the reason why I want to talk about that is because it's a very, very serious issue. The magistrates are very concerned about this area. And it is mandatory consideration. If there are parties who have children in either of their homes, it's a mandatory consideration. The court must consider naming a child. So if a child is exposed to domestic violence, when they are comforting a person who has been abused, seeing mum or dad with bruises or injuries, scratch marks, black eyes, broken nose, broken teeth, all of those kinds of things. Cleaning up property damage. I've been working in family law for almost 5 years. And I often see and hear stories from my clients around how when there has been an explosive behaviour in the home where children help clean up the mess, that's exposure to domestic violence. And also experiencing financial stress caused by economic abuse. So kids having to be suddenly changed schools because they can't afford the school fees, all of those things. That's a very discrete area of exposure to DV. But things like seeing mum or dad get really, really stressed about money because they've got nothing, but then when they go to dad's place or mum's place, whoever might be controlling the purse strings, it's all such a lovely, lavish life. That's actually creating a dichotomy which affects a child's views in the world about what's actually going on, and that child is actually being exposed to DV. Let's go into some definitions now. I'm just conscious of the time. Emotional abuse is often a question, and I do note that came up in the pre-webinar question list about proving emotional violence. Ultimately, it's a hard one to prove, but the thing is that it's a pattern of behaviour, and emotional abuse, when it's well documented and very clear, it's quite straightforward to demonstrate or to be able to chronologically show that there has been behaviour which torments, intimidates, harasses, and or is offensive to another person. Threatening to withhold medication is something that occurs often with people who have complex mental health issues, chronic illness. It's one that we do see in the GSD community or the LGBTIQ community, people withholding medication or access to medication for chronic illnesses, including hepatitis, HIV, which is incredibly damaging to people's health and well-being, both on a physical and mental health issue. Preventing a person's contact with family or friends, repeated text messages, email, or misusing social networking. Social networking is a wonderful example of how you can actually demonstrate emotional abuse because there's a pattern of behaviour. Text messages, it could just be a repeated message that a person receives every day at 4:35 in the afternoon, 25 minutes before they leave work for the day, and it's, where are you, how far away are you? That's a really good pattern that, when you're dealing with people who might not realise that they're using controlling behaviours or emotionally abusive behaviours, that those kinds of message over time create a pattern of intimidation or harassment to a person. And the other one is repeated derogatory taunts. Putting it bluntly, the common stuff is, the name calling, the putting the parenting down. Be careful with that if you're giving advice that, this isn't family law proceedings, but, calling someone a bad parent, and the colourful language that people often use, unfortunately, to describe the other parent, it's a derogatory taunt, and you should always caution your clients around their own behaviour and their own language that they use when talking to or about another parent. Economic abuse, again, this is why we're going through these lesser known examples. I think we can all understand what physical is, but going into economic abuse, coercive or deceptive or unreasonably controlling behaviour that denies economic or financial autonomy or fails to meet reasonable living expenses. So removing or keeping property, for example, phones. There are a number of cases which talk about the misuse of phones or taking phones from people. There can be questions raised about or pressure applied to people to claim social security payments. So the old, we're not in a de facto relationship. Let's not tell Centrelink that. So we're gonna lie to Centrelink. Coercing a person to sign documents. If you haven't already read up, please Google sexually transmitted debt. I do believe there's a webinar on sexually transmitted debt on the Legal Aid YouTube channel. So I would really strongly recommend that you go and watch that. And also preventing a person from seeking employment. And that might not be just seeking employment as in getting a job, but applying for promotion or applying for something that might improve themselves, okay? Moving on to, so we've talked about relationships, we've talked about acts of domestic violence. Now we're going to talk about the final element being necessary and or desirable. Necessary and or desirable was too big using my text, so I just changed it to necessary and desirable. They can be necessary, can be considered as a singular point, and desirable can be considered as a singular point as well as a point considered together. So section 37, the court must be satisfied that the protection order is necessary and or desirable to protect the aggrieved from domestic violence. In deciding if a domestic violence order is necessary or desirable, the court must consider the principles of the Act, see section 4, and may consider whether an intervention order has previously been made and if the respondent has complied with this order. When we talk about intervention orders, it needs to be acknowledged in this as part of this webinar that history of violence is a key indicator of future violence. So there can be a major issue which people don't consider, which is that people might have gone into an intervention order before as part of police application, and what's happened is that that intervention order has never been complied with. When it's come back to the court for a application to vary, whether it be brought on by the client or the police, one of the key questions that the police will ask is, was an intervention order made? The magistrates will consider is, was an intervention order made? Has it been complied with? Because this court is primarily concerned about risk and ongoing safety, and orders which promote the safety and well-being of an aggrieved person, but also orders which promote an aggrieved person living their life free from violence. So that's why it's such an important point to talk about today. The case of AJS and KLB, which is a 2016 Queensland District Court decision. You would have heard me talk about risk. Risk informs every aspect of practice in the domestic and family violence space. You must always assess risk for your client and risk for others. So this is the case where we talked about a 3-stage risk assessment supported by evidence to determine whether or not an order is necessary and or desirable. So we must assess the risk of future violence in the absence of an order, and it must be more than a possibility or speculation. You must assess the need to protect, such as where they live or where they work, and where they will have opportunities, or whether or not the parties will have opportunities to interact and communicate. That means if parties have mixed property or children, that's something that the court must take into consideration as to whether or not to make a protection order. And furthermore, to assess whether it is necessary and desirable by reference to the objects and principles of the Act. So that's why I spent some time on it, ladies and gentlemen, is because that informs every aspect of your practice. Now, I just want to note a few other things that other case law informs us. Briganshaw and Briganshaw, which is a family law case. I'm not going to go into it right now, but the seriousness of allegations and credibility of the threat is relevant. The consequences of making an order should not make an order or not should always be considered. So that means whether you make an order or whether you don't make an order, what are the practical consequences that could occur? And again, when you go back to the objects and principles of the Act, when you're looking at a history of violence, what are the consequences? That's really bringing those two cases together. And also, really important point, good behaviour during the existence of a temporary protection order in itself is not a significant indication that there will be no future domestic violence, as it involves an element of self-interest. Really good case. Often when I'm at court, I hear solicitors and support people tell me, oh, but there's been no breach of the temporary order. My most common response, and sometimes my bluntest response, is, so they're doing what they've been told to by the court. Doesn't really fly with the magistrates. And it shouldn't either, and it doesn't at law. So there you go. If you're thinking about making that submission, don't. Now, this is my favourite case at the moment, BJH and CJH. The nature and frequency of violence is a relevant factor. And why it's such a relevant factor is, as you would have seen in the earlier case, it does talk about risk assessment. And what we know about nature and frequency of violence is that it can really inform the court about the future prospects of violence, as well as what can happen. What can happen if the court doesn't make an order. A recent case where I've had some work on was a matter where honour killings kept on being raised consistently, and so there was grounds to actually ask for more than 5 years, and we did so because of the nature and frequency of the violence. Similarly, in another case, there was a history of I think it was about 12 years since separation, and every time an order finished, there was more written letters, poems, all of those kinds of things. We successfully argued for a 10-year order in that matter. Now, when you're talking about nature and frequency of violence, this is why this case is so important. So the lawyers who are out there, please read it. Admittedly, I love this case, so I'm very biased. It is a bit of a law nerd moment that I'm having, but ultimately, it's a really useful case to talk about nature and frequency, and also provides a great definition of harassment, and a recent definition of harassment. Now, another aspect of the Domestic Violence Act is that the ordinary rules of evidence do not bind the magistrate's court. Section 145, this should form part of your gospel, and also for social workers or people who are working alongside people who live with violence. This is where I would encourage you to think outside of the box where you help a client. It's not always possible to get screenshots or social media shots from the client's phone because it might be broken, etc., etc., etc. However, if they can log into a phone at court, I have relied on Section 145 and handed the phone up as a duty lawyer and said, Your Honour, pursuant to Section 145 of the Act, I seek to dispense with the rules of evidence, and I'd like you to see screenshots 1, 2, 3, 4. Please swipe right, and you'll see the 5 that we rely on. Obviously, caution your client about what also might be on their phone and that they might not want a judge to see, because otherwise they can make admissions about other criminal aspects as well, which we don't want them to do. But it's an important thing to consider if you are practicing law in this space. The ordinary rules of evidence do not bind the court. By no means expect to go into the court and then think that you can basically throw the baby out with the bathwater. That's not something that you can do. You do need to seek permission. And you need to make sure that you highlight to the court that it may inform itself by any way that it considers appropriate. Now, if his or her honour decides not to listen to that submission, that's fine. It's a may, it's not a must. So the benefit of, and the reason, the theoretical reasons behind Section 145 is an acknowledgement from the drafters of this legislation that sometimes the evidence in these matters, it's really difficult to find, really difficult to demonstrate that evidence to the court because violence is often behind closed doors. So It's important to remember as well that there is no need to have the personal evidence of the aggrieved before making a domestic violence order. That's to think about with respect to applications made by the police. It's a very common occurrence that we see in our practice. We service a number of courts through the duty lawyer function, and every year when we do our training, we often hear a story about an aggrieved person who doesn't support a police application for domestic violence because there's been consequences or they've been coerced and they've decided that they don't want to continue the application, but ultimately it's not their application, it's the police's. So that's how this section starts to apply across the legislation. Now, importantly, a temporary protection order need only be supported by evidence that the court considers sufficient and appropriate, having regard to a temporary nature of an order. So you don't actually need the necessary and desirable, you just need the first two, that there is a relevant relationship and acts of domestic violence. Obviously, again, the court can inform itself by any other information, which may include history of orders, criminal history, etc., particularly if you're operating in those dedicated courts like Southport, Beenleigh, Brisbane, or in Northern Queensland and Townsville. You are looking at magistrates who are very savvy, who are very aware of the world around them and how the arms of criminal law can inform this court. Making protection orders. Now, for those people who may be operating in a community legal service, giving a multi-pronged advice to a client, when they come in with a criminal issue where they've been charged with a domestic violence offence, a court can make a protection order at the time of conviction, and it also includes that a protection order can be made in child protection proceedings. Just again, if you are, once you have given advice or supported a person through to a final order, please make sure that you encourage your clients to report breaches to the Queensland Police Service. Unreported breaches just make aggrieved lives harder. And always consider what resources are available to you and to your clients about reporting to the police. If you don't have a tip sheet, find one. There are some great tip sheets out there. I believe Women's Legal Service is a fantastic tip sheet. Legal Aid actually issues a tip sheet as part of their advice when they close a file to their clients. So there is the information out there, and I would encourage you to make your own tip sheet, which might meet the unique needs of your clients. Just really think about that. Now, just a quick, who's been listening? Protection orders can be made on a temporary or final basis. True or false?
This is the last poll today.
Last one I'll make you do. 100% true. Congratulations, we all get a gold star, and I can't give that to you because it's a webinar. So we'll just go to the next one. So just making protection orders, just some points. Sections 37 and 44 apply. They can be made ex parte on a temporary basis at the first mention. They can be made on a temporary basis at any stage of the matter, which means that if the court doesn't make an order on the first return date, it can make it on the second or the third, and a final basis at any stage of the matter. So once service is affected, should you be assisting a person who is a respondent, they should always go to court, always go to court, because if they don't appear, an order can be made against them. And also that actually prevents the respondent from accessing information and understanding what an order might mean, and how that might impact on their relationship with their children as well. So it's always important for a respondent to attend court. And obviously agrees if they've made the application, otherwise it can be dismissed. I talked about that earlier, about making temporary orders, about making sure those two elements are there. So I'm not going to go into that any further. But I will say to any party assisting a client making an application for a protection order to always tick the box saying, I want a temporary protection order. And if it is an urgent matter or immediate concerns are there for an aggrieved person, please make sure you outline the urgency and those safety concerns in the application underneath the relevant section under both the temporary order and the grounds for a protection order. So making final orders, we've got to that point. I'm not going to go into that any further than what you can see on your screen. Now, again, just that caution, if you're assisting a client through the protection order process and they're a person who's been accused of committing acts of domestic violence, please make sure you send them to court, because again, that's their opportunity to engage in this process, to get further information, to possibly even educate themselves about domestic violence and what is domestic violence, and get an intervention order which can actually really improve, give them an opportunity to educate themselves about what domestic violence is and how it might impact on their children. And ultimately, what we want here is people to be more responsible and better parents, because we don't want this cycle to continue. Future violence, or the risk of future violence, or using violence as a communication tool, what the social science is telling us is that if you grew up with violence, you're more likely to use violence, a risk of being in violent relationships. So it's really, really important that we have that meaningful conversation with our clients about improving ourselves to be the best person or parent or partner that we can possibly be. Now, when a court can make an order, you've got some different options here. An order can be made on a without admissions basis. Really, really important. So if you're assisting a client who an order has been made against, or an order is potentially going to be made against, and you'd like to ensure that they don't incriminate themselves or have a finding of fact against them, the without admissions consent order can be a really effective way of doing that. Now, I will note that it's the discretion of a court to not accept consent if it considers that a consent poses a risk to an aggrieved or a named person. I've very rarely seen that occur. I can only think of one example in the 2 and a bit years that I've been with Legal Aid where that hasn't been accepted, but that was a circumstance where a further act of domestic violence was committed in the court. So again, making a final protection order on the balance of probabilities, the court must find that the parties were in a relevant relationship. The court must find that there has been an act or acts of domestic violence, and that in all the circumstances a protection order is necessary and or desirable to promote the safety and well-being of the aggrieved and any named persons who live with violence as part of that relationship. So, applying for a protection order. This is really top tips for everyone here. It's got to be in the approved form. Always state the grounds. Question 4, question 6, always make a response. Always state the nature of the order sought. So if you don't want contact, say that you don't want contact. If the form is asking you what further conditions, go through and really consider what further conditions are going to be practical, what orders are going to promote the safety and well-being of a person living with violence. So the 2 approved forms, DV Form 1, DV Form 4, there is a link later on to the court website around the online form that you can use. It can be a really good way of basically using the wonderful world that is technology to help write your application in a form which it automatically creates everything for you, is justified, and goes through all of those wonderful things with formatting that I'm really bad at. So make sure you jump on the link if that's something that you might need assistance with as well.
Just a reminder, you can download the PowerPoint slides in the handout section, so you'll be able to get the link straight from there.
Okay, so now it's an important thing to note that sometimes, and this feeds into a question that was raised prior to this this webinar, which was sometimes people aren't ready to leave a relationship. And when people aren't ready to leave a relationship, what happens is that the court sometimes will only make an order that's standard conditions and send people away to do an intervention order, to do a course of counselling, and really encourage people to take some steps and basically give them a chance. That's not a common occurrence, but when it does happen, this is a really important thing to consider. We can always apply to vary a protection order. So if the original protection order is failing to provide the level of safety for an aggrieved person, or alternatively, that the parties have gone off and done some courses and done some, soul searching and assisted support around how their relationship works and how their relationship dynamics have led them to violence, it might be appropriate to vary a protection order to reduce conditions. Reducing conditions is rare, particularly where a police application has been made, and particularly rarely grant where there's some severe acts of domestic violence, including strangulation or allegations thereof. Really important if you're assisting a client apply for a variation that you get the original copy of that application, because often people aren't forthcoming about the level of violence in a relationship, and that will cause some questions of you if you're a practitioner or a social worker, and you're in court and the court makes some inquiries about what did you know when you assisted this person. So just really important to consider when you are reducing conditions. So the court must consider the grounds of the initial application, any findings of fact, and also compliance with any intervention orders. I've just realised I left the words voluntary. It's no longer voluntary. It is an intervention order, not a voluntary intervention order anymore. The court must consider past compliance, non-compliance with the intervention order. So it's something without making compliance, let me rephrase that, sorry. When the court varies the order, it must consider past compliance and non-compliance with an intervention order without making compliance a reason not to vary an order. So that's situations where the court will consider, for example, compliance with an order. So he or she has gone off and done a course of counselling relating to behaviour change, but there are still risk factors that haven't been addressed: alcohol use, drug use, mental health issues. That increases the risk as part of that risk assessment, and the court's not going to be satisfied that that's enough. We've just talked about the safety, protection and well-being in the reduction of conditions, and I will highlight that the court must consider the wishes of the aggrieved. Just because the court must consider the wishes of the aggrieved doesn't mean that that's going to be that's actually going to be something that the court will take into consideration. So I'm going to jump through a few of the next slides about conditions of orders. Mandatory conditions: good behaviour, not commit acts of domestic violence. That also applies to named persons and children. And there are prohibitions on contact, following or approaching or returning to a person's home or their place of where they may live infrequently or where they work. Also prohibitions on contact in the sense of how they recover personal property. Important thing to note: personal property is not getting a removal truck. It is essential items: toothbrush, personal documents, passport, ATM cards, etc. That's it. Restrictions on social media. Again, image-based abuse is a growing issue. We need to deal with this as practitioners and workers in this space, and we need to support our clients, and sometimes giving that advice about getting off social media for a time as well. And we've talked about naming children, unborn children, and relatives and other persons. The court must consider naming an unborn child, and I will highlight that very clearly for you. Okie dokie. Mandatory considerations: court must consider imposing any other condition. That's just how the lay of the land is, ladies and gentlemen. the court must consider making further orders, whether or not it's been asked for. So your client can go in and ask for a good behaviour order, but realise that there's such a history of domestic violence that other orders are needed, or other police reports have been made, there's ongoing investigations. Any of those things that the court may be aware of will take into consideration, and your client can go in thinking they're going to get a good behaviour order, but they might get a lot more. Ousters. That responds to a question prior to the webinar. Ouster orders can be made. It's about the safety and stability of children who live with family violence, minimising disruption and retaining continuity and social connections and support for an aggrieved and children. Okay, that's where the return to property comes in. Naming children. Again, court must name the children. Okay, plain and simple. It's about protection of the child from associated, which is direct domestic violence or being exposed to domestic violence. Okay, the court can request information pursuant to request information at the time from child protection, who must comply. Okay, so if child protection is involved or might have been involved, the court can get that record of record relating to the parties and the child. Altering parenting orders. I was going to go into this, but in the light of time, I might cover this in webinar 3, which will be in another couple of months' time, talking about altering parenting orders. Never give advice if you're a lawyer about altering parenting orders. It is something that the court, while seriously considers, in varying a protection order, it's only, or varying a family court order, it's temporary. It is not a, it is not something that people go into. There has been a very recent case that I've only just read yesterday about cost orders that were made in a domestic violence proceeding where the magistrate viewed that the parties were using the domestic violence proceedings to interfere with parenting orders. So, in summary, get comprehensive legal advice when asking to vary parenting orders pursuant to Section 78 of the Act. Just proceed with caution is all I can say. Intervention orders, this goes back to the objects and principles. They're intervention orders, they're not voluntary anymore. If the court orders you to do it, do it. Advise your clients that it's always about improving yourselves, and that's why we're all here. That's basically, the message of that. And I will also say that these intervention orders they are at the attention of the magistrates. And that's a really important thing to say, is that, we're all aware of intervention orders. Anyone who works in this space regularly is very aware of intervention orders and the benefits that can come from these intervention order programs. Duration of the orders starts the day they're made. They're 5 years now. The court must give reasons if they're going to make less than 5 years. Some of those reasons can include that there's no real reason for people to continue to be in contact with each other, and that's something that I'll also cover in webinar 3 is duration of orders, and about making submissions about that. But ultimately, 5 years is the go-to. If you've got kids, if you've got joint property, you're going to walk away with a 5-year order, because ultimately it can take time to resolve those issues and allow the venom to move out of a relationship between two people. Again, that's just highlighting the changes in 2017. It's all new. So it's new Section 97(1), new Section 97(2), and new 97 subsection 3, if I can use those words today, which apparently I'm having trouble with. Again, it's the magistrate's responsibility to explain to both parties what the consequences of an order is and how an order works. The court must use interpreters. There is a practice guideline that you should be relying on. Please go onto that practice direction and take a copy of it with you to court if you're working with called clients on a regular occasion. People who are working on a ad hoc basis with people who have a called background, please use your own initiative and write to the court and highlight to them that a party may need an interpreter to understand the proceedings at all stages. That helps the court allocate time, allocate resources, and that's how you can really meaningfully change the experience of domestic violence court for a client who's of called background. Okay, practical hints and tips. Always, always, always encourage a client to get legal advice before completing a document. If you don't have a referral pathway with legal aid, please get in contact with us so that we can help provide advice or assistance to your clients, particularly before providing or swearing a legal document where they are financially eligible. Always address the elements of domestic violence using headings: relationship, acts of domestic violence, and then subheadings of physical, emotional, economic, threatening, coercive. Use your headings because that helps the court make decisions, and always inform the court of a client that you may be assisting with who is called or has a hearing impairment, so that the court can make arrangements for interpreters. The hearing impairment is a big one because you can't do it over the phone. You need an in-person interpreter. Now, legal aid. We have a telephone advice clinic for people who are living with violence. Calling 1300 6511 88 is the first step in getting them some advice. I'm one of the lawyers who mans that phone line. So you do get your clients in contact with people who work in the DV space every single day. Again, referral pathway, referral pathway, referral pathway, referral pathway. I can't say it enough. Please get in contact with us to create a referral pathway, particularly if you're not a legal advice clinic or a service, so that you can assist your clients getting practical, pragmatic, and forthcoming legal advice about these issues. And always check. I did note that there was about 35% of attendees today in regional Queensland and far north Queensland. Touch base with your local court, find out if there's a duty law service or specialist DV court in your region, and again, contact Legal Aid Queensland to see what other things that you can do for your clients to make sure that they've got legal advice or assistance on that day. And that can include a regional office appearing by telephone on behalf of a client, and that can make the world of a difference for someone who's living in a regional or remote place in Queensland, and at least having a lawyer helping them either immediately before the day or on the day itself, pursuant to a grant of aid.
And we also have some media releases. You're welcome to check our website to see
Yep.
if we posted a media release about a duty lawyer being in one of the regional towns on the day.
Absolutely. There's your online forms about online application. Really good tool that I see a lot of people using as self-represented litigants to provide the relevant information to the court about what's actually going on in their lives. Now, there is a number of court videos that have been done by the Department of Justice which explain the court process. That was a joint effort by Legal Aid Queensland, the courts, and Department of Justice as well. So there was, and also feedback through the Women's Legal Service and things like that to get that happening. Now, I will briefly touch on an emerging issue within the domestic violence space at the moment. LGBTIQ relationships, LGBTI relationships, or gender and sexually diverse members of the gender and sexually diverse community are experiencing rates of domestic violence which are the same as, if not higher, than the heterosexual population. They're a vulnerable community. What I would strongly suggest to everyone out there who are either a lawyer or a social support worker in this space is encourage yourself, encourage your colleagues, encourage your services to go and attend some training about the GSD community or the LGBTIQ community, depending on which acronym is being used in your area. GSD is more of an emerging one. to be more inclusive of the things that don't fit strictly underneath the LGBTI flag. The other side that I do want to highlight is that there is a heteronormative lens of violence in perceiving LGBTI incidents of violence. That's where people have a preconceived idea about who is a perpetrator of violence. You know, the concepts of your butch lesbian or your feminine gay man, and unfortunately that informs an invisible lens of homophobia from lived experience in reporting and in accessing services. So I would like to highlight that there is help out there for people in the GSD and the LGBTIQ community. The first point is the 1300 number that I've talked about in getting them some assistance, and also engaging in services as quickly as possible. I will highlight that there is a limited support structure for the GSD LGBTIQ community in seeking social assistance. It is there. First point is, if you are a social worker or a lawyer in the area, go and speak to your own GP and say, look, this is the area that I work in. I want to get some help in my clients. How can I refer them best to these services? Do you know of any? It's your own research. If you're in a regional area, that has been a question that has come through on the seminar, and there is absolute, and I very much appreciate that question from Jenna about having a low uptake of the LGBTIQ community. It can be really simple, and that's what that inclusivity training is all about, is about how to make your service and yourself appear more LGBTIQ friendly. And also, I think that is it actually. Yeah, that's it.
Thanks for listening in today, everyone. If you have to leave us now and you had a question, you can email us at webinars@legalaid.qld.gov.au. Otherwise, we'd just like to invite everyone to stay back for another 10 minutes so that we can get through any questions you might have. We've got a couple we might go through that were asked before the webinar. If it's been covered in the presentation, it'll just be a good reminder for everyone, and we'll give you a couple of minutes to start asking your questions through the questions bar in the toolbar now. So Jason, if both parties apply for legal aid, how is it decided who is represented?
Okay, I would encourage everyone to look at the guidelines about funding for people who agrees and respondents to protection orders, where there are cross applications. Our grants team take into consideration a number of things in giving aid for both parties. Ultimately, it's a decision for grants, and it's based on the material that's provided by the clients to grants. So basically, is their application supported by some evidence? Is it not? Is it actually domestic violence? Is the other thing. Sometimes people write an application, their cross application is actually all about parenting, so they won't get DV legal assistance, but they might get a grant of funding for family law mediation. So that's a really difficult question, because it actually isn't encompassing all of the things that go into our grants team about funding domestic violence. Ultimately, it does mean where two parties are funded by legal aid, I will strongly say that they are not going to be represented by the same legal aid organisation or the same preferred supplier. It will still be treated with the respect and the ethical and professional standards of pursuant to the Australian Solicitors Conduct Rules, and conflict searches are done. So in terms of who gets represented, it depends on their circumstances. The best way to assess as to whether or not a person's going to get a grant of aid is by reviewing their circumstances against the guidelines. So I know that's not an answer, but unfortunately that's the only answer I can give.
It's always worth applying, you never know.
Absolutely.
And we can fund both parties, should they both be eligible for legal aid funding. Then one might be in-house and one might be a preferred supplier. So it's not a matter of if the woman gets in first, the man can't be funded by us. There's still a chance that we'll both be funded.
Yes.
Okay. How would you best suggest supporting people from diverse cultural backgrounds when there's a language barrier not supported by the legal system?
I think that's where we'll go back to what I said earlier about making sure that you're engaging with the court. So if you're providing one-off assistance to a client as a lawyer, or if you're providing ongoing support through a domestic violence support service or counselling service or community organisation, the best thing that you can do is you can write to the court and put it in writing, always put it in writing. Write to the court and explain to the court who you are, that you've been assisting this person, and that they need help on the day. You need to put in place that they may need an interpreter to understand basic principles and what's going on in court. And if, I will say, we talk about language barrier as well. If they're a person who is hearing impaired or sight impaired and they need assistance, definitely write to the registries. Give the court a call first, find out what their email address is, and then let the court know, because there is a practice direction which requires magistrates to consider arranging interpreters so that people can understand what's going on. And if you are within distance of a specialist court, consider taking them to a specialist court, because there are some really, really good services available. And I will say, so far as not inconveniencing or putting the safety or well-being of that aggrieved person at risk by going to a specialist court. But I will say that all courts are bound by the practice direction, and you should certainly just write to them and make sure that they're aware of what's going on and what your needs of your client are, because ultimately that's why we're all here.
Thank you. So we've got another question. Someone often has clients who don't necessarily want to get a domestic violence protection order because they feel like it might aggravate the offender. What tips would you have for people in that situation? Because there's no guarantee that it will be accepted.
The common conversation around domestic violence orders where people are concerned is that, and I hear it so often, it's just a piece of paper. Yeah, it is. There's nothing that I can say that disputes that. It's a piece of paper. So if you're concerned about applying for or assisting a person or encouraging a person to provide for a protection order because it might increase their safety risks, there is always the option of not applying for an order and then going through a really comprehensive safety plan, changing your number, moving house, removing yourself from social media. Fantastic outcome. Particularly if the nature and frequency of the violence is using not by telephone but by email. Change your email address. No, we shouldn't, and I absolutely acknowledge that these are the things that are changing the aggrieved's way of life, in the sense that the whole point of the protection order is to minimise disruption. Unfortunately, an aspect of what we do has to be a consideration of what is practical, what is pragmatic, and if, for example, if you're coming back in 2022 to vary an order to increase it by another 5 years, well, firstly, you need to think, is there any reason for these people to be in contact? And if there isn't any reason for these people to be in contact, then maybe by re-engaging the domestic violence trigger and an order trigger through the legal system isn't the answer that they're seeking. It might actually be about personal resilience, which is something that I'm a lawyer, not a psychologist or social worker, and I can't give that advice. But it's about thinking outside of the box and saying, okay, well, what are the triggers for this person's safety, and how can we help on a practical basis and improve someone's safety through a practical outcome as opposed to a legal solution. Now, I just want to jump on one thing that I saw about the stats in the LGBTIQ community. I will say that there is a report from Child Family Community Australia, and there's not a lot of research out there, and it has varied significantly about the statistics. but they will. The Australian Research Centre for Health and Sexuality conducted a national demographic and health and wellbeing survey of LGBTI people in around 2006, and identified that 25% had experienced sexual assault within a same-sex relationship. That 41% of the respondents who identified as male had experienced physical violence within same-sex intimate personal relationships. Now, those statistics move so much because of the internalised homophobia and also perception of homophobia. So it does vary significantly depending on which resources you're looking at, and it does vary significantly. But what the more recent surveys, and I don't have them with me at the moment, is that same-sex attracted men experience violence at a similar rate to heterosexual men in intimate personal relationships, and then the same-sex attracted women experience it at a slightly higher rate, and then it increases for bisexual, the bisexual community and also the trans community at the highest rate of experiencing intimate partner relationships. So that's just a quick note. Yeah.
We've got two more questions. We'll quickly jump through them if you'd like to wait around. So yes, the recording is available today, by the way, someone's asked that. So it'll be available on our YouTube channel in the coming months once it's been captioned and published. Okay. So someone's got a client who has relatively young children. The young children are being aggressive towards the parents. What would you suggest the parent do in this situation?
A protection order can't be sought against a child where the child's under 18. That's the law. If you've got issues around children being aggressive to a step parent or something like that, once they are 18, then they can be considered for a protection order. Ultimately, that sounds like an issue that needs fairly high level intervention from a conflict resolution service of some description. Probably my first step would be going to Relationships Australia and saying, hey, what can we do? And then also talking with Headspace and things like that around what services can we provide for this young person who's being quite aggressive towards the parent. An order can't be made unless they're in an intimate personal relationship under the age of 18. That's what the law says. So my advice would be really comprehensive safety planning, engagement in children and young people mental health, because if that is a trigger, you need to go speak to your local KIMS about it and get a referral for that, and then engaging with other services that actually might help the person who's experiencing violence to set some really clear safety plans as well as boundaries in the home, so that if situations occur that they can get out quickly if they need to. And obviously severe violence, O, any threats of severe violence, O, threats of self-harm, O, and please make sure that you advise your client to prioritise their personal safety above everything else.
Thanks, Jason. That's all I've got time for today. If you've got any other questions, you're welcome to email us at webinars@legalaid.qld.gov.au. And just a reminder that if you've got clients and you think they may need legal help but you're not sure, please call us and we can help you. If we can't, we can refer you to someone else who can. So thank you for listening in, and thanks again to Jason for your comprehensive webinar today, and stay tuned for part 3.
No worries.
See you later.
Thanks.